Good morning and welcome to Estate Planning for Seniors, Securing Your Legacy. I'm Lori Hendren. I'm a Senior Associate State Director for AARP Illinois, and we are thrilled to have you all joining us today. I see many of you are from Georgia, Virginia, and across the nation, and we welcome you. Our focus for today's discussion is on elder law, with a little special focus on estate planning for seniors. And as always, to shed light on this very important topic, we have our special guest, Steve Andersson, an elder law attorney in Illinois, and also a contractual lobbyist for AARP Illinois. Welcome, Steve.
Thank you so much. I'm happy to be here as always.
Love having you. And for all of you that are joining us live, we welcome you and we thank you for coming because AARP is made better by you and we are here for you. Please put your comments or questions for Steve or AARP in the Facebook or the YouTube feed so we can be able to get to those during today's event, and we're going to do our very best. We do have some questions already generated to get the ball and the discussion going, and it's going to be at a starting point. We're going to have discussions, and it's going to be planning, consultation. But remember, during this whole conversation, please contact your professional advisor on elder law, financial planning, or your medical professional on your healthcare needs. Those are your first go-to. Keep in mind that the specifics of elder law may vary in jurisdiction. So again, consult with your elder law attorney. Financial advisor is advisable for personalized guidance. Steve, are you ready? I got some questions.
I'm ready to go, and I just want to encourage people, although we do have our own set of questions to get the ball rolling, I really encourage you, if you have questions, put them in the chat. We'd love to handle them live, but absolutely.
This is why we do it. Yep. Absolutely. So one of the questions was just interesting that kind of came from a former viewer we weren't able to address. How can older Americans effectively structure their estate plan to ensure their legacy and basically protect their assets for future generations?
Sure. So an important question and a good question, and not an easy one. Let me start by saying that I'm a licensed attorney in Illinois, as Lori said, but we know that this program goes out beyond Illinois state boundaries. So we're talking to people in other states. So I'm giving you what I would characterize as answers that are generic. In other words, they probably apply to any state, but they're not exactly specific to any state, including Illinois. So like Lori said, it's really important that you can take what you will from our discussion, but you do need to double check it with an expert within your own jurisdiction. So with that in mind, the question of how do you structure your estate plan really depends largely on the size of your estate plan. And second, the complexity of your wishes. For example, if you have a small estate, let's say, I don't know, maybe a house and $100,000, right? I don't know if that's small or large, but let's just use that as an example. And your family is small. You have 2 kids, maybe, and each of them had a grandkid, which is wonderful. I have 1 grandkid so far. Let's say that's it. In large part, you don't have to do too much to make sure that if your intention is to divide equally between your family members, that's going to happen. Now, is it a good idea to have a will that specifies any particulars? Yes. Is it really, really important for you to have powers of attorney and durable power of attorney for healthcare? Yes, and we'll probably talk about that in a little bit. But specifically, if your estate is relatively uncomplicated and you're giving it to the people that most of us expect, your children, you don't have to do that much. You don't even technically need a will in most states because that's where the states would normally send the money, even if you were intestate, which means no will. But I still recommend that you have a will. So that's at that lower level, and in that level, I think the protection is solid because you keep the assets in your name until your death, and then you move them very seamlessly to your heirs or beneficiaries. So that's kind of the bottom level. Middle level, let's say above that, but you don't reach the thresholds where you're talking about big estate taxes, which is when we're up in the millions of dollars. If you're in that middle ground, which I think a lot of people are in, now you definitely do need a will at least, and you might want to consider a trust. A will goes through the probate process, which is a court-appointed process for making sure that your assets go where you want them to go. And then a trust is outside of probate. So it saves some money on the probate side of the expenses, and that's attractive to a lot of people. And it's also a little quicker. There's no real time delays for getting things from the trust to your beneficiaries. But there are good reasons, bad reasons to have trusts, so don't always assume that that's the right thing for you. So if you do that, then you are absolutely, well, I can't say absolutely, but you are 90% guaranteed that where you want things to go is where they will go. So that's valuable as well. Now, let's say that your estate plan, your wishes, where you want things to go, are not quote unquote normal, right? It's not 2 kids and a couple of grandkids. Maybe you don't have any children and you have areas where you want your estate to go that is not what people would normally expect. That's why it's really important at that point to either have a will or a trust, so it specifies those things. Also, if you have assets that are personal to you, a painting, something that is personally matters to you, and you want it to go to a specific person, you have to list those out. Otherwise, it won't necessarily go there. So trusts and wills are the way that we make sure to protect that your assets go where they need to go. Last, third category, those millionaires in the room. And my congratulations to you for having those assets and being very blessed. In those cases, that now involves tax law as well. So I'm not going to tell you what to do. Everything I told you so far is true for you as well, but you have an additional layer, which is tax planning. And that goes beyond the scope of what we could talk about today, other than talk to a good attorney about that.
Wow. That's a lot there. And for our over hundreds of viewers that are coming and also from Texas, we welcome you. We've gotten some questions. So I'm going to bring some of these. I think they're follow-up questions, Steve.
Good.
If you're single and you have no children, you know, what kind of path do you do? I think it kind of goes to the tiers, right? Lack of a better term of, if you have no children, if you have children, if you're a multimillionaire, it's really going to be based maybe on your estate. What's your thoughts on that?
Yeah, if the question is, if you're single, no kids, what do you want to do with your estate? I think it's important to note that you get to do whatever you want. There is no right answer. Like there's not like, oh, I'm single and I have no children, so therefore I must give my money to so and so. There is a path, like Lori said. If you don't specify, that would probably go back to your parents or your siblings if you had siblings, but your parents may not be alive or you may not have siblings. Doesn't matter. In those circumstances where it's not clear, that's where you should have a will or a trust that specifies where you want it to go. And that can be anyone. It can be your best friend. It can be a donation to charity. It can be split amongst many people. If you can envision it, we can write it. We can make that happen. So I think that that's very important for you to recognize that. Don't hesitate to be creative because all of that can fit within the boundaries of a will or a trust. Does that answer that question, Lauren?
Yeah, I think that's great. So we have another one from YouTube. I have a trust and I have a will. I'm looking to avoid probate. So how do I transfer my assets and trust to my children equally without the will and thus probate?
So you're good to the caller. Sounds like you've done some planning. Congratulations. And it's good planning, because what I would tell you if you were my client is you need both. You need both the will that you have and the trust. Now, if your assets are properly titled into the trust, in other words, your house title, for example, isn't in your own name, it says the estate of Steve Andersson, for me, for example, the estate of Steve Andersson, or pardon me, I misspoke, the trust of Steve Andersson.
Mm-hmm.
As long as it's labeled that way, and all the major assets are labeled that way, including bank accounts and things like that. As long as that's done, those assets are in the trust. There'll be nothing left in your estate, in your will. So the will is just a backup document in case something is forgotten or left out. If that's the case, then we deal with that isolated thing. but all your assets will flow through the trust to whomever you want, and you will have avoided probate. Now, most of the time, the people ask me, well, what will be left, in the will that might have to go through probate? Well, sometimes people acquire a new asset and they forget, right? Maybe you buy a car and you just get it in your own name, and the car has value, and so you want to sell it. That would end up in the estate. But depending on the value, most states have a threshold where below a certain number, you can use what's called a small estate affidavit to transfer it anyway and still avoid probate. So there are many different ways to get away from that. The last item, though, and this is why even if you plan perfectly, let's say you plan just absolutely perfectly, you got all your assets into your trust, and you're like, I'm solid, I don't need a will. You still need a will. You know why? Because there are circumstances you cannot possibly plan for, which is what happens, and this is tragic, but what happens if you are hurt, injured, or killed in an accident?
Right.
There is a claim then, because if somebody did you wrong by doing that, there's a claim. That's an estate claim. You can't put that into the trust because it didn't exist until you died, and then you didn't have time to put it into the trust. So always remember, you need that backup will for that reason.
Wow. Okay, so we have another great question. And I'm going to reaffirm, if you're joining us, please put your questions or your comments. And this is just guidance information. Please talk to your elder law attorney or financial advisor to make sure you're getting the information. This is a very much an educational event. This is a great question that came up on YouTube. There's a lot of software that's out there, right? And I'll be honest, thank you for the profession, but going to an elder law attorney is kind of pricey, especially if you're having to pay for prescriptions, your mortgage, property taxes. It's a lot of money. So if there's software, and this is not an endorsement of any software, so we're not going to name names.
Right.
Is it safe to use this software that is marketed to help you create, and it's legit, these wills or these trusts, and then you can just bring it and pay for 20 minutes for an elder law attorney to review it and sign it or to witness it? What is kind of the insights and the guidance for people who are looking to plan and trying to manage a budget at the same time?
Right. And that's totally reasonable and legitimate. We all have to watch our finances, and there's no question that going to an attorney can be expensive, although I would also argue that they may save you money in the long run for errors or mistakes that software might not be able to catch. What I would say, though, is there are legitimate times when you can use software. And if we go back to my 3 tiers of estate planning, or sizes of estate and complexity of estate, the lowest one, the one where I said you may not even need a will, that would be perfectly appropriate to use that software. And also the ones where your estate plan is not complicated. Again, I'm using the very stereotypical, you have 2 kids with 2 grandchildren. That's pretty easy. And so the software can handle that. But if you start getting into complicated, I want, 1/3 of my assets that are in this bank account to go to this person, and I want 2/3 to go to another person, and they're not your straight linear children and grandchildren, then those software programs are going to fail you, and it will probably not work. And I would advise against them when we're talking about trusts, because trusts really are complicated, and then you don't have the benefit of the court, to clean some mistakes up. So if you're doing a trust, you really should talk to a professional on that. And then, of course, at that 3rd tier, that the millionaires in the room, or billionaires, I don't know. Those people you have enough money. You hire qualified professionals. You need that.
Yeah. So another great question. Thank you. Keep coming with your questions and comments.
Yeah.
This is individual who lives in a state, I'm looking this right, has assets covered in a will in that state. But like many who have worked very hard, they have property in another state. They may have a vacation home, let's say in Florida. Does your will in your home state cover your other property outside of that, your home state's?
Right.
Yeah, your home state.
Right. And so, kind of the corollary is, do I need a will in
In the
Florida?
other state, right?
Let's say you live in Illinois, but you have the home in Florida. Do I need like another will? The answer is no, you don't. The one will, because you really can only have one will at a time. You can always change it, revoke it, make a new one, but only one is in effect at a time. You can list that Florida property in your will and say, I want this Florida property to be sold and divided amongst my children, or I want it to be given to one child or one person. You name it. You can do what you want with it, but you have to specify that. Now, here's where the complication comes in. And Florida is a good state to use as an example because they are very picky about how they do their probates. You will have to set up what's called an ancillary probate. You could even avoid it in Illinois and still maybe have to do it in Florida. And so what they're going to do is they're going to make you hire an attorney in Florida to process that one asset. But it will still be processed in accordance with your wishes with the Illinois, in our example, with the Illinois will. So you only need the one will. You can specify property outside of the state, but it might set up a little bit more effort in that state to finally close that out.
Well, that's fascinating. So if you are planning and you have a property, let's say in Florida with this extra level, is there anything you can do in advance so your loved ones doesn't have to kind of be in shock and awe? In a will, does it state, or do you get something already set up, or do you get it, stamped by a witness? Is there any guidance on that you can do again to build that legacy and make it easier for your loved ones?
Yeah, I mean, the trust is one way to do that. But regardless, all of that is documented.
Okay.
It is witnessed, it is certified by the witnesses that everything that was done properly, and that you were of sound mind and body. Not necessarily body. You don't have to be of sound body to execute a will, but you do have to be of sound mind. As long as that's done, that aspect of it will be smooth.
Yeah.
It'll go fine.
Another great question. A man and wife have their benefits rolled over and they're defined as their kids as their beneficiary. Do they also have to define that rollover and benefits of that beneficiary in their will, or just naming it on the form with your retirement as your beneficiary? Is that sufficient?
So we're talking about probably like a 401k
Yeah,
or
like 401k.
403b,
Yeah.
right? The IRAs and things like that. So it is technically sufficient to just list those beneficiaries on the bank or the financial the firm that's managing it. Those beneficiary designations are sufficient. And by the way, if that's all you have, that also avoids probate. You don't even need a trust for that. If those beneficiary designations are made, like, well, I was going to pick a investment company, but I probably shouldn't. So I'll just say XYZ investment company. You fill out their forms. It'll honor your wishes with that. So that would work fine. There are tax implications for your beneficiaries on those tax qualified distributions. Most of them are advantageous to your children. They can roll them over. In other words, if it was pre-tax dollars, for example, and they inherit those pre-tax dollars, they could take them out, but then they're going to have to pay the tax on that you would have had to pay in that year that they take them out. But they can roll them over into their own IRA or other retirement-based qualified plan. With the exception, there's been some recent changes that might require them to have required minimum distributions, RMDs, within 10 years that they distribute the amount that they received from their father or mother. So that gets a little technical. I don't want to go too deep into that, but there are lots of advantages in those circumstances. So definitely in that case, talk to a financial planner, tax planner, because they'll be able to help you in particular with those sorts of distributions.
Another great question. So when someone is planning their financial accounts, a lot of times when you may have that initial discussion, by the time you're passing, let's say 10 years later, you haven't updated, the amount of money you had has probably gone down. So what's best? Or what is best practice? Is it to say a percentage will go to X person or X organization, or is it a dollar amount? What is it? Because you could, if 65, I have 250,000, but by the time I pass at 75, I've spent down, I may only have 30,000. How
Right.
do you handle that?
Right. Great question, by the way. So there's no right answer to this. It's what you want to have happen. I would suggest that a common way that people like to approach this is if they are looking to be fair, and you don't have to be fair amongst your family. You can do what you want. But if you're looking to kind of equally distribute, use percentages. Don't use dollars. Say I give 50% of my estate to my daughter, 50% of estate to my son. Don't say 100,000 to my son and 100,000 to my daughter, because there may not be 100,000. Or what if there's more? Then what happens? So the percentages are a better way to do that. Now, if you have someone, let's say I'm a beloved caregiver who isn't your son or daughter, and you don't want to leave them your whole estate, but you want to give them some amount of money, it's okay to say, I want to give that person $5,000. Then you can use a dollar amount for that. It's possible that if you were to go below that amount, they wouldn't get it, because if you can't get money you don't have. But that money, just so you understand, that $5,000 in my example, that's the first thing off the top. So they get their money, and then the percentage beneficiaries, the ones who receive money based on the percentage, will get what's left. So the specific designated beneficiary gets their money first.
Okay, so another question came up, and you have asset protection
Yeah.
and I think you may have touched on this a little bit, but there's a lot of things that happen that maybe not planned for. How do you, in conversation with your tax attorney or elder law, how do you get that asset protection as you age?
So that's a big question. There's a lot of potential there, because we could be talking about fraud, and abuse, or we could just be talking about mistakes and things like that. What I think, number one, I'm going to advise, because we haven't talked about it yet, is the idea of powers of attorney. And in this context, powers of attorney are there, especially with money, to name someone that you trust, to help manage your assets. That's huge, because that means you've got somebody you can have help. So if as you age, you feel like you're not up to the task, or you're not quite completely understanding the implications of an investment, or somebody tells you you owe them money that maybe you don't remember, it's someone you can go to who will be able to help you. And then if they don't know, they can go to an expert, financial person or an attorney, and find those things out. So I would say number one is something like that. Number two is, a lot of times people will ask, well, what if I need to go into a nursing home? Is there a way to protect my assets? And there are some ways that you can shelter some assets and still qualify. There used to be a lot, but over the years, the government has kind of tamped down on those. But there are ways to move assets into different categories that would be protected if you had a spouse that might otherwise be required to be used to pay privately for your nursing home care before you spent down to Medicaid levels. So there are strategies to do that. It's way beyond the scope of this conversation to go much deeper into that, but there are things like that. And I want to throw out one more for you. And this is kind of it's just something I worry about with people. Medicaid or Medicare Advantage. Medicare Advantage is a legitimate thing, I suppose, but it's not Medicare. It's a different system that purports to be cheaper, sometimes like no premiums. And that's very tempting, right? If you're in that category. I caution you, the other side of Medicare Advantage is less coverage. And so that can be very dangerous, especially if you suffer an injury and need rehab. The time they give for rehab is a lot shorter that they approve than traditional Medicare. So I just raised that because when we're talking about protection of our seniors, I want to raise that because I've seen it. So.
This is a great question. One of the questions we've also included is, As you navigate that complexities of Medicare, Medicaid, if you're, if you have a loved one or even yourself spending down and having to go to a nursing home or in Illinois, it's a community care program, long-term care
Right?
in home. How do you plan with your state plan to cover these future healthcare needs? I mean, let's be honest, if something happens, God forbid you get COVID and you get a chest infection and you're hospitalized for 4 weeks, that's a large financial cost. So how as you start having this conversation with your loved ones and you especially with your elder law or your financial advisor, how do you plan for that complexities?
Yeah. And it's a complexity that you don't know is going to happen.
Mhm.
You know, that's the other thing is we don't have a crystal ball about our future. Maybe you'll live your life fine and die in your sleep if that's your desire. On one day, no pain, no issues, right? But the other possibility is that you do need nursing home care or you do need rehabilitative care for a period of time. And in your example of 4 weeks or something like that, the bills could be huge. So, how do you plan for that or how do you prepare for that? You can do some small things. You can do health savings accounts, that segregate some pre tax dollars if you're still working to try to help with that. But honestly, it won't be enough to handle a major item like that. So, then it becomes, have we done any planning that would help us qualify for Medicaid, so that we get some government assistance beyond what Medicare covers. In those circumstances, you generally can't plan ahead, but you can plan after it happens. So it's kind of like post planning, because if you're married, particularly if you're married, you can move assets between spouses to exempt them or protect them. It's harder if you don't have a spouse because there are less abilities to do that. But there are a few ways to do that. And I always say this during our program, and I forgot to say it this time. It's gonna be okay. All right, that should be my tagline. It's gonna be okay, because even in those situations, let's say where you go into a nursing home and you're worried about running out of money, as long as you're spending down legitimately on that, when you run out of money, Medicaid will pick it up. And I was talking about this with Lori yesterday. The nursing home can't discriminate against you. They can't lower your level of care just because you turn over to Medicaid. So the quality of life that you're having can continue. So that's an example of it will be okay. And most everything we've talked about today, even if you make a mistake or even if you don't do anything, you listen to this program, but you say, I don't want to do anything, it will be okay. The systems are set up in our government and in our states to make sure that people's assets generally go where you're going to intend. Like I said, if you have different ideas about where they should go, that may not work out, but generally, you're going to be okay.
Wow, this is wonderful. And we have had so many wonderful questions. And I know there's so many more in the feed that we can't be able to get to because we're about 1 minute shy of our 30-minute programming. But I know we have put for you, if you're joining us, a link to register for our next upcoming event with Steve virtually. And we're going to keep tackling these questions and listening and having conversations and being able to provide the little bit of education. But again, we affirm that please reach out to your financial advisor, your elder law attorney, to make sure you're getting the help that you need. So we want to really thank Steve for being here with us. He is wonderful as always, and we learned so much, his expertise and insights. And Steve, if many of you don't know, Steve and I lobbied together in Illinois State House on caregiving and nursing home issues in the state of Illinois. So we are very much attuned to these critical issues and understanding the importance. For those of you who are looking for more resources on caregiving, you can find valuable information and support at AARP website. It is www.aarp.org/caregiving. And please take advantage of these resources to help you navigate your caregiving journey. Once again, we want to thank you all for joining us, giving us part of your day this morning. And we look forward to continue supporting you, your caregivers, and the entire aging community, not only in Illinois, but across the nation. I hope you have a wonderful day. And thank you again, Steve. On behalf of Steve and I, thank you, and we hope to see you again. This concludes today's event. Thank you.